Everybody, Jonathan here. Hope you guys are all doing well. We had a bit of a cold snap here. I'm in Atlanta, Georgia, and it was really cold. We actually had snow. We rarely get snow in Atlanta, maybe once every 2 or 3 years. Sometimes even longer than that. And last Friday, it snowed. We had about 2 or 3 inches of snow. It lasted, started raining kind of middle of the day. And there's still some patches around, but mostly gone. Although I understand that next week or next 10 days, there's supposed to be another Arctic blast that's going to get us again. I don't like cold weather, so kind of ready for spring, but it is what it is. So anyway, I hope everybody's doing well, and wherever you are, that you are staying warm. Because again, when it gets really cold, it can get really, really dangerous. Again, in Atlanta, if it's in the mid 20s, that's really cold. I know Jen, my paralegal in Lincoln, Nebraska, she was saying it's 10 degrees up there. So that's really cold. So anyway, let's kind of get right to the questions. And of course, please post your questions. I will be happy to answer. Hello, Jenny Joe. Hope you are doing well. We have someone named S. Mintix who I think I thought it was 7:30 Eastern, but it was actually 7:30 Pacific, which is 8:30 Eastern. Laura, and I know you've been in touch with my office, and her question is, I have serious back pain, but if I get radio frequency ablations in 6 spots, 2 epidurals for leg numbness and trigger points, and they all work great, will I disqualify myself from SSDI for stenosis? And I think she adds to that, I need a knee replacement. Should I do it before or after I qualify? And then should I consider paying my physical therapist to fill out a residual functional capacity with your initial app? When would SSD ask for that? So let's kind of break these down. I would say this. First of all, your onset date is relevant here. Realize that in order to qualify for disability, you have to have a condition that has lasted or is expected to last 12 months, 12 consecutive months. So if it's already been a year or close to it, and you go through these procedures and you're better, you could go for a closed period. So that's one option. The second thing I would tell you is you should do what you can do to make yourself better. Social Security, and I'm looking at what you had sent me a few days ago, or actually it was last September, I'm going to think of it. You've got, based on what you've told me there, I think you've got a good case. But I would also tell you that Social Security can be really unpredictable. And even the strongest cases sometimes get a really bad judge or a bad adjudicator. And so you never know what's going to happen. So I would say focus on what you can do to make yourself better and let the chips fall as they may with Social Security disability. I would not hold off on taking a procedure or hold off on medications or surgery or whatever you need to do because you're thinking it may screw up your Social Security case. Focus on getting yourself better. And if Social Security is in the, is part of that equation, great. If it's not, if you get yourself better within a year, and again, it's already been 6 months or so since you originally contacted me. So let's say you go through all these things. You have your radio frequency ablations, epidurals. By the time you know whether it's going to work, it will have been a year anyway, depending on when, again, your onset date. So again, focus on getting yourself better. The last thing you want to do at a hearing is walk in there and for a judge to think that you've not done things that you could do to make yourself better. Now, I will tell you that under the law, deciding not to undergo procedures, surgery, even epidurals, anything with risk, they won't hold that against you. They realize that any procedure has inherent risks. So if you choose not to, they don't hold it against you. But if a judge senses that you're trying to game the system, they're not going to come out and say that in the decision, but that will work against you. So I would just tell you, focus on what you can do to get better. And again, if you have to make your case a closed period, you do that. If it doesn't work, and realize if you've got significant disc issues, my experience has been radio frequency ablations, epidurals, they give you temporary relief. It's not going to solve the problem. If you have a bad disc issue, herniated disc or something like that, a radio frequency ablation, it burns the nerve, then it regenerates. It's not going to solve the problem. So I don't think these things are more than temporary fixes. It may give you a little better quality of life for a period of time, but unlikely to resolve the problem completely. And the same thing with the knee replacement. Yes, before the knee replacement, you have more argument to say that you wouldn't be reliable at work. But, knee replacement's a big deal, big surgery. It's going to take, 6 months, 8 months to recover anyway. If it's something that your insurance will cover and your doctor feels you need to do it, listen to what the doctor says. Don't worry about the Social Security part of it. Again, in your case, you've got back issues in addition to knee issues. So again, don't hold off on that. And as far as the physical residual functional capacity exam, and what she's talking about here is that many physical therapists will do a formal functional capacity assessment. I had a hearing today, and my client had a physical therapist do a functional capacity assessment. The conclusion was that she was limited to less than sedentary in terms of her functional capacity, which means that, that would, most judges would say, that's a winning argument. You can't do even a simple sit-down job. So if you can get one of those, the sooner you can get it, and you submit it with your application, submit it with the recon. As soon as you've got it, get it submitted. But that's not a bad idea. Now, realize on the flip side is, if you go through that and you have an evaluation and it comes back and it says you can do medium work, or it's evidence of malingering, bad stuff, you got to still submit it. You can't leave it off your Social Security file. So, if you decide to go that route, you're going to have to submit it because it exists. Social Security doesn't let you selectively, leave stuff out. But yeah, I think if you can get that and it's supportive, it can be very, very powerful, very strong for you. So yeah, I think I wouldn't hold off on treatment. And if you can get a functional capacity evaluation, a formal one, that carries a lot of weight with most judges and with Social Security. So I think that would be helpful. And in fact, that might even increase the chances, it likely would increase the chances of an early approval as well. Okay, Christine says, Social Security's doctor, and she was apparently sent to a consultative evaluation, said that I could sit for 8 out of 8 hours with a 5-minute break every 15 minutes to alleviate back symptoms. Is that going to be helpful to my case? Well, a 5-minute break every 15 minutes. Okay, well, let's see. That's going to be 4 or 5, 20-minute break every hour. How many employers are going to let you take a 20-minute break every hour? None. If that's what the report says, that you need a 20-minute break, away from the workstation where you wouldn't be able to focus at work. And again, that's the important part. If you can take the break, sit, stand, that's different. But if you need to be away from the workstation or not focused on work, then that 20-minute break is what they call in the Social Security world being off task. So if you're off task 20 minutes an hour, that means that you're essentially going to be off task for a third of the workday. That is disabling, if that's what that says. So in that sense, it would likely help you. I will tell you that generally speaking, the Social Security consultative evaluations are usually, the physical ones in particular, are rarely really very helpful, because most of the doctors that do physical consultatives are doctors that insurance companies use to deny insurance claims. Not all, and I think we had a consultative doctor, John Foster, on a few weeks ago, and he's not an insurance company doctor, and he does things a little bit differently, but a lot of them are industrial clinic doctors who will, basically say there's nothing wrong with you. I looked at one, in fact, my case today, where I had, the functional capacity evaluation. There was a consultative by a PA, not even a medical doctor, and essentially, the lady can work 8 hours a day. Well, this lady had significant neck and back injuries, multiple herniated discs, stenosis, and she has a blood clotting condition that she cannot take epidural. She cannot undergo surgery because they would have to take her off the blood clotting or the anti-clotting medication. And she's using a walker and a cane. I mean, there's no way this lady could possibly work. Yet the consultative report said, oh, she could work. But there may be some other issues that might interfere with that. I mean, it was a bunch of BS. So again, a lot of times you see that, but I think that if the doctor is saying you're off task 20 minutes an hour, that will strongly help your case. Absolutely. Okay. Let's see here. We've got L. Brown saying, good evening, Happy New Year. Happy New Year to you as well. I hope that you are doing well. I hope the new year, this will be a good year for you. S. Mintix, who was asking about the time. 49 near Austin. Is that bad? Is that 49 degrees near Austin? I'm not sure if you're 49 years old and you have a case out of Austin. Not sure what you mean, but 49 degrees is better than 29 degrees. So not too bad. Not too bad there. Angela Brothers, good evening. You're an excellent. Well, thank you, Angela. Wanted to know, can Social Security tax your back pay and lawyer fee you paid? They will not tax the legal fee that's withheld. As far as the taxation, it's going to depend on your household income. And if you type in to Google, go to Google and type in taxation of Social Security disability benefits, there is a pretty good article, a couple good articles out there. I think one is from, now that I got to think about it, let's see, taxation, SSD benefits. The IRS has something there. TurboTax has something there. There's several different ones that talk about that. So in general, it's going to be if your income, it says here, if your income is between 25 and 34,000, you have to pay income tax up to 50% of benefits. More than 34,000 annually, up to 85% of your benefits. This is one of these tax questions that I would talk to a tax preparer about. Generally speaking, if your only source of income is Social Security, you're probably not going to pay much, if any, tax. If you have other income, dividend income, things like that, household income, a spouse, then there may be some taxation of it. Which again, if you think about it, you're paying taxes on money that you've already been taxed on, which, is kind of ridiculous. But the answer to your question is sometimes, yes, there could be taxation on disability benefits, but not on money that you did not receive. So if your lawyer got paid $5,000 or $6,000 or however much money for representing you, that was not paid to you. You won't get a 1099 for that. That's actually what they do, is they send out 1099s. I get one for the fees that I've earned, and my clients get it for the money they've got, but they don't get 1099 statements or reporting of income for money they did not receive. Money that went to the lawyer does not get charged, is not taxable to you. Carolyn, hey Carolyn, we communicated by email today. I'm glad to see you here. You said you were going to be here, so there you go. There you are. Nice to see. Nice to see you on this forum here. And I hope we'll continue our conversation. Gen Z Wright, I was just approved after hearing on Tuesday. Wow. Okay. Well, you got a hearing on Tuesday. You already got an approval. That's pretty rare, but that's cool. How long will it take to get your letter and then start getting money? Generally speaking, it normally takes about 3 or 4 weeks to get a written decision. So I'm guessing the judge said to you at your hearing, what's going on up there? I hear a big bang upstairs, so I'm not sure. Hope there's nothing going on up there. What's likely happened here is that the judge announced at the hearing that you're going to get approved, which is really nice. And I've had that happen a number of times. I love it when judges do that because it just takes the uncertainty out of it. Normally, the written decision, which will say fully favorable on it, will be issued in about 3 to 5 weeks. What happens is the judge writes down his or her notes, and they send it to a writer, which is typically a lawyer, a couple years experience, who's in a cubicle someplace up who knows where. I had a gentleman named Cameron who used to work for me, and Cameron, after working for me, went to law school. Then because he had done some Social Security for me, he went to work for Social Security as a decision writer. And so, in fact, I interviewed him on my podcast. If you go to SSD Radio and just search for, Cameron, his last name is Khanna, Connah. If you search for that, you'll see the interview. But basically, Cameron said that, if you can imagine a building, with several floors of cubicles, and you got these writers, and they're listening to the tape, and they're looking at the judge's notes and looking at the evidence, and they draft a decision using a template. And it just depends on how backed up they are. Now, I will tell you that, and I will tell you this, I have tried a bunch of cases. I'm probably trying 10 to 15 cases a month. So let's say I had 10 or 12 in November, 10 or 12 in December, round numbers. And in January, I've gotten 2 decisions issued. obviously they're backed up, and it may just be because of the holidays or whatever, but they're a little bit behind. So I'm guessing that your situation, unless you get lucky, it's going to be probably closer to 6 or 8 weeks before you get a decision. Really frustrating, I know, but that's just because they're backed up. Now, sometimes on a fast one, a judge will, they can expedite it, and the decision can be written in a more informal way, and the judge just kind of summarizes things, and boom, you get it out. Or the writer is able to knock out some of the easier ones much more quickly. Although Cameron told me, interestingly enough, that the favorable decisions took more work than the unfavorables, because the judge had to justify awarding benefits, knowing that the appeals council would be looking at the award. So take that as it is. But the bottom line is that you can expect to wait 3 to 4 weeks at least, probably 5 or 6 at this point in time. Now, 2 months from now, maybe less, but right now, that's what's going on, I think. And then about 2 or 3 weeks after you get the written decision, you'll see the deposit. That's usually what happens. Couple of exceptions: if you have an SSI case, they have to do what they call an income and resource interview. That will delay things further. If there's any sort of red tape of some nonsense, whatever, then it could delay it further. I've had cases where there's immigration issues. I have one right now where they paid me the wrong amount, and they overpaid me, but they sent me a letter saying, we're supposed to pay you X and we paid you X, which makes no sense because they paid me what they said they were supposed to pay me. I looked at it closer and I realized they made a mistake and they overpaid me. So I sent the money back, but that delayed the funds being paid to my client. So, you're dealing with an overworked bureaucracy. So like I said, on general, best case, you wait 3 to 5 weeks for decision, another 2 weeks for money. So you're figuring about 2 months after your hearing, you should have your money. Now I would tell you 3 months, maybe even 4 months, unfortunately, before you see your money. Okay, Barry, Cuba. Do folks 62 and older still receive CDRs? They can, Bori, Cuba. They can. It's pretty unusual, and the reason why is that at 62, you're really close to retirement. And realize when disability, if you get disability, you remain on disability until you hit full retirement age, 66 or 67, they automatically convert it over. Obviously, at 62, you could take early retirement. You're not the demographic they're going after. They're looking for people in their 30s, in their 40s, who are going to be claiming money from the Disability Trust Fund for the next 20 years, 25 years. 62, you're just not on their radar. Now, if you went to work and the earnings record showed you had significant earnings, they could do it. And they certainly can do it. There's nothing that says they can't, but they don't. I mean, they have limited resources, and the money they want to spend on reviews is not for people in their 60s. It's for people in their 20s and 30s and 40s. They want to get those people off. Because people younger are going to recover likely. If it can be recovered from, they're going to recover from it. 2, they want to minimize the drain on the trust fund, and who would you want to spend your time going after? Somebody who's going to be draining, or I should say draining, but claiming against the trust fund for the next 30 years versus Bori, Cuba, who's going to be going against the trust fund for the 3 or 4 years. It's just a matter of economics. So that's my take on it. I've never seen a CDR for anybody in their 60s. Tara Denise. Hello, Tara Denise. I'm currently receiving SSDI, worked 26 years as a pediatric registered nurse, and I continue or apply for widow's benefits. Whatever is higher. And normally, if the widow's benefits would be higher than your SSDI on your own earnings record, Social Security will figure that automatically and bump you up. But you can find out what the widow's benefits are. If they are higher, you've already been deemed disabled. It's just a matter of contacting Social Security and saying, hey, look at this. I'm entitled to more money, as a disabled widow than I was on my late husband's earnings record than I was on my own earnings record, and that would be an automatic. How many people on here right now? Esmentic's 109 people are on here, which is great. I'd like to get it to 200. That's my goal. But right now we're at 109. Kelly says, if my case file MDI, I guess that's medical record, says severe, but the functioning is mild and moderate, Is that a bad thing? Social Security is going to focus on the functioning. So there may be a disconnect between what an MRI says, like let's say a stenosis. It says severe stenosis, but a doctor says that will cause mild to moderate functioning limitation, something to that effect. The functioning is going to really be the important thing, because Social Security disability defines disability in terms of how your medical issue impacts your functioning. So if your functioning is only mildly impaired, that's not going to help your case. But I think you could certainly argue, if you see something severe when it comes to a herniated disc or stenosis, then you could certainly make the argument that the doctor's conclusions about your functional limitations are, maybe a little bit overly optimistic. And realize that different doctors read MRIs, I'm assuming it's an MRI, differently. I remember I had a case several years ago. I think I still have the MRI report sometime around here, where my client had gone to a doctor as part of a workers' comp case, which brings its own complications, but set that aside for a second. And it was an workers' comp doctor, reads the MRI and says, there's very little wrong. This person can do X, Y, and Z, blah, blah, blah. My client's like, I can't function. So I said, let's do something a little different here. Let's get the films, the actual films, and get another radiologist to read it. And I actually have a friend here in Atlanta who owns an MRI clinic. And so I called him and said, can I, how much would it cost me to have your radiologist read this? I'm not going to, say what I wanted to say, but just how much would it cost? So it was like, I don't know, 150, 200 bucks. He got me a deal on it, basically his cost. So we had the radiologist read that MRI. It comes back with much more significant limitations. So literally the same films, two different radiologists. One had a workers' comp employer bias, the other had no bias, and got two different readings. So that could be what's going on there as well. I think that the conclusions are going to be by a doctor or radiologist, but don't accept them as gospel. It's just, if there's a bias there, that could be what's going on too. All right, Rodney. Rodney's here almost every week. Good evening. Looking forward to another year of informative videos. Well, I've got a bunch of them in the can. I've got a bunch that I've been working on coming up with topics. And what I do, by the way, is I'll kind of brainstorm some topics, and then I'll create like headlines and 3 copy points, and then I'll come down here. You can see my camera right there in the background, right there. And I'll go ahead and just record, they call it batch recording. I'll record 10 or 15, at a time. And then my son will edit them. My son works for Adobe, and on his, just as a side gig, he'll edit my videos. And so, we get them out that way. Then we release them, 2 or 3 a month, but I usually batch them. But I'm always looking for good ideas. So if anybody has any ideas about videos, definitely let me know. 57. Okay, I guess at that time, now it's 116. So people watching. All right, Angela Brothers. My review is coming up in May. What do I need to know? I'm in my 40s. I got approved for disability reviewed every year. This is my first review. What will happen? Well, generally speaking, what they will do is they will send you one of 2 forms. One is called a short form, which is basically, where they're asking you, have you worked? And they ask you, has any doctor said you've got improvement? Or have you had any improvement? And, if that's the form and you basically say no work, no medical improvement, nobody said I'm better, you send it back in. Most of the time, they just mark it as no improvement and wait till the next time. There's a long form, which is a lot more detailed, that they would ask you to fill out, where they're asking for information about your medical treatment and so forth. If they send you that one, you want to fill that out, and then it goes to Social Security, kind of like the same people who did the initial evaluation, and they will make a decision whether they feel like your answers there warrant a consultative evaluation. They want more information, and they will the adjudicator would make a decision, yes, there has been improvement, or no, there's no improvement. And then, and only then, would they send you a notice. If they decide there's been improvement, they'll send you a notice of intent to terminate. You have the right to appeal that. It's basically a reconsideration. You also have the right to continue receiving benefits while you appeal a termination. So realize they first have to make a decision that they've got to review it, and so you have time with that. Then they've got to make a decision that something significant has improved, that you are not disabled anymore. Then they give you an opportunity to, to contest that. Now, if you choose to receive benefits while you're contesting it, and you've got to do that, by the way, within 10 days. I know these rules are ridiculous. You get a notice of intent to terminate benefits. You have 10 days to ask that benefits be continued while you appeal. The problem is if you do that, then of course there's no past due benefits. So if you want to get a lawyer, you're not going to be able to do it on a contingency. By the same token, if you say you're not asking for benefits to continue and your benefits, past due benefits begin to accrue, you could get a lawyer, to do it on 25% retainer, if in fact the lawyer felt like there was good evidence of that. Now, obviously, when I'm looking at those, if the person was already found disabled before and nothing significant has changed, that's a pretty good argument there. But that's kind of how it works. As far as what to do, there's really nothing you can do other than to continue to go to the doctor. If there's any objective tests you can, get, go ahead and get those. If you want to get a functional capacity evaluation with a physical therapist, that could be something to do. So it's just, the same thing you'd be going through when you're applying, but you've already been found disabled. And obviously they're looking for medical improvement. And so if you have evidence from your doctor that there's been no significant medical improvement and that your functional capacity to work is not any greater, then hopefully that you should not have any problems with that. And also you're in your 40s, again, if you're in your early 40s versus late 40s, that can make a difference as well. Miguel Mitchell, thank you for this information. Thank you, Miguel, for tuning in. I appreciate that. I hope you're doing well. Tara, let's see. Okay, I was approved for SSDI in June of 24. Lori got fees for the back pay. Now I'm receiving a bill for over $600 for medical records. They requested, wouldn't that come from the back pay money? Generally not. Social Security is a little unusual in that they basically send the attorney 25% with a cap. It was $7,200, now it's $9,200. 25% of past due benefits. If the lawyer wants to ask for expenses, he has to file a fee petition to do that. I don't believe it's appropriate for a lawyer to ask for expenses without getting permission from Social Security to do so. So that's the question. Did he ask Social Security for the authorization to charge you fees? I will tell you, in my practice, one of the big changes for the better has been that there's a lot of ways to get medical records very inexpensively or none at all. So except in rarer cases, I don't ever charge any file costs because there are none. I can get them on a portal, download them from a portal. I can have Social Security get them through something called HIT, Health Information Technology. It's free and immediate. There's something called the High Tech rule, which allows you to get them for like $10 or $11. There's a lot of ways to do it. Now, back in the bad old days, we'd have to request medical records, and we might get a bill for $150, $200. And in those situations, if you get, if you incur expenses of $500 or $600 for medical records, you're going to ask your client to reimburse you. But nowadays, it's just pretty rare, in my view, for lawyers to have any file expenses. Now, if the lawyer had to pay a doctor to write a functional capacity evaluation, it's not inappropriate to ask for that money back. But I still think that's not part of the back pay. The back pay is only the fee. This is expenses, is a different thing. But my understanding is that in order to collect expenses, you've got to file a fee petition to ask the Social Security to authorize them to do that. And they depend on you to do it. And if the lawyer did really expend $600 for your benefit in a one-year case, then pay them. I mean, that's the right thing to do. Terry Clemens, is it good that the appeals council remanded my case to a different ALJ in the first remand hearing? Probably. I mean, again, you could get a worse ALJ. You could get an ALJ with a lower approval rating. But, usually if you're appealing an ALJ, it's because you felt the ALJ made a mistake, so why not have another pair of eyes look at it? And of course, the ALJ you had originally may have retired or moved on or something. But I would say on balance, yeah, it's a positive. But again, look at the approval rating for the new ALJ, and you could be trading one bad or low approval, shouldn't say bad, but low approval ALJ for another low approval ALJ, which doesn't really help you very much. Sneevy. I was wondering if traveling out of the country for a few weeks to visit a sick family member would work against me while initial SSD application is being processed. I don't think it's going to make any difference to the adjudicators. If you get in front of a judge, the judge might ask you, have you traveled any place? And if you traveled out of the country for a few weeks, the judge will want details. What did you do? Was it sightseeing? Were you, how was it, if you have back problems, for example, how did you deal with being on a plane for 10 or 11 hours? So, it could raise some questions, because if you're saying I can only sit for 10 or 15 minutes, but you sat on a plane for 10 hours, there's an inconsistency there. If you went, it sounds like, visiting a sick family member, it's not like you're going on tours, but, if you go someplace and you decide to take a tour because you happen to be there and you climb castle walls or something like that, then yeah, that's inconsistent a little bit with, being disabled, especially for physical stuff. So, I think it could be a factor down the road, probably not. And again, if you're simply going there and you're in a house with a sick relative, and you're just there to provide moral support and you really don't do anything different that you would do at home, then, what's the difference other than explaining away the traveling? And, I've had people say, well, my traveling was, I was on a plane for 4 or 5 hours and I got an aisle seat. I was getting up every 15 or 20 minutes walking around, or I rode in a car and I had to stop every 30 minutes. So, I don't think it's if you can explain it, I don't see that as a huge problem. Again, touring, sightseeing, taking bike tours, yeah, that's more of a problem. But visiting a sick relative, I don't think that's an issue. I had a case not too long ago where my client, her daughter paid for her to go, on a vacation to Europe, and she slipped and fell like literally the first day, and she spent the entire time in a hotel room. And so that came up at the hearing. So that can happen too. Ms. Crystal had my hearing, and my lawyer said they'd amend my offset date. I think you mean onset date. What does that mean? Well, basically, when you apply for disability, you allege what is called an onset date. That's the start date, onset, as the first date that you became disabled. And in some situations, the onset date is not supported by the medical record. So the judge might ask your lawyer, would you consider changing the onset date from February 5th of 2021 to, July 3rd of 2023? Of course, that means less past due benefits, but a win is a win. And, I've had situations where the medical evidence was not supportive. I told my client this is likely to happen. And I said, we probably want to think strongly about taking it. I try to spot those ahead of time, if I possibly can. I've had situations where the judge says, well, let's change the onset date to, November 2024, which means my client gets no past due benefits. And, I'll tell my client, you have the option here, no past due benefits, you'll win for ongoing benefits. But, I think the evidence is strong enough to support an approval going back to our original onset date or a different onset date. So I'll argue with the judge. I've had arguments, respectful arguments with the judge, and we'll push it back. I'll try to argue to push it back. Or you could just say, no, we're not going to amend the onset date. And the judge could issue a partially favorable decision, and you could choose to appeal. So, what's concerning a little bit here is my lawyer said they had to amend my onset. They need to talk to you about that. They shouldn't just amend it without talking to you. So if the judge or Social Security called and said, you had your hearing. So if the judge said at the hearing, would you consider amending to, July 5th of 2023, your lawyer, what I would do is I would say, Your Honor, if I haven't already talked to my client about it, I would say, Your Honor, can we go off the record for about 5 minutes so I can talk to my client? And then I would, they would pause the hearing. I would, pick up my phone and call my client. Sometimes the judge says, well, I'll step out of the room. You could, if you want to believe it, but usually I'll just call my client and say, this is what's going on. What do you want to do? and they'll say, what do you think I should do? And I'll give my opinion as to, I think the evidence is weak enough over, before the onset that I think it's probably not a bad thing to do, or I think we ought to just say, no, we're going to stick to our guns, and we think that the onset is what it is. So that's just what it is. That's how I would deal with that. But again, that's not something that your lawyer should be doing without talking to you, because it's your past due benefits and it's ultimately your case. As Mintix, my fear for the future, like CDR as a provider in whose view I'm improved, but not from where I sit. And the lengths I'm going to in order to heal are extensive, not like I'm dying to be on SSDI. Yeah, that's a legitimate concern, because there are some doctors, and I've met a few of them, who do not believe in the concept of disability. And, the other thing is doctors want to believe that the treatment they're offering, the medications, procedures, advice they're offering, is going to help you. And, for a doctor to basically say, well, all the stuff I've done has done no good at all, that's kind of contrary to what, they want to see happen. They don't want to be sued for malpractice. It's just, it's like anything else. If you have a vested interest in that the work you're doing, or the efforts you're providing, or providing some sort of value, it's really difficult to say it's just not working. Now, obviously, in the middle of treatment, doctors are going to say, well, this, epidural didn't work, or this medication didn't work. That's part of the overall analysis. But, if somebody's, trying to get better and the doctor's doing things, it's going to be, could be hard for the doctor to conclude that what he or she is doing is not really helping. So that is, yes, a concern. I think you want to pay real close attention to the notes being produced by your doctor. And if you start to see things in there that are not consistent with what your life experience is telling you, then it may be time to look for a different doctor, or to at least raise the issue with the doctor. Like, look, I'm looking at your notes. You're saying, that I'm only having, migraine headaches once every 3 weeks. Well, that's not the case. I'm having them twice a week, and they last 45 minutes to an hour. Would you please correct your record, or write a letter, even better, put it in writing saying, I'm looking at this, and respectfully, I disagree. Now some doctors will be upset about that. They're like, I'm not changing anything. But, if you're misquoted, you need to kind of get that corrected. But yeah, I think you just want to really pay close attention to what's in your medical records, so that if there are any issues that come up, you've put into writing your disagreement with what the doctor has said. And again, if you get the sense the doctor is one of those who just doesn't believe in disability, then it might be time to look for a different doctor. Degrees. Okay, so I think you were saying that it's 49 degrees in Austin, I believe is what you said. That is not too bad. 49 degrees, it's still cool, but, a sweatshirt, or maybe I'll like when I go out and play tennis when it's 49 degrees, I may wear a long underwear top, a long sleeve t-shirt and a sweatshirt. And by the time I'm playing, I'll probably end up taking the sweatshirt off. So it's not terrible. 49 degrees I can live with. Okay. Terry Clemens says, how would a cane and wheel walker and a handicap parking meter help my case on remand? Didn't have all this from my original hearing with the ALJ. Double-edged sword, in that, that suggests that your condition has gotten worse. So, you got a remand because the judge made a mistake for the appeals counsel in or district court in your original hearing. And so when you're going back for another hearing, the judge now is going to look at this and say, what is his condition as of his original onset date going forward to the present? Well, things have gotten worse. So if you're a judge, you might say, well, let's find out when Terry got the order for the cane or the walker, and we'll make the onset date that date. Cuts you out of a lot of past due benefits. On the other hand, it does signify a significant worsening of your condition. So, the argument you can make is that as of my original onset date, I was at a disabling level. It's only gotten worse and has not improved. And the fact that it's gotten worse shows that this is a pretty serious problem. But the risk is that a judge might look to see about using that to amend the onset date to cut out past due benefits. So it just depends on kind of what the entirety of the record says. If you have a lawyer, which I assume you do, I would talk to your lawyer about that, whether to make a big deal about the fact that there's new stuff in there that shows you're more disabled. The other part is you might look at this and say, well, there's some weaknesses in my original case, obviously got turned down. Maybe we, assuming we still have the insurance credits, maybe we amend our onset date and try to make the judge's life easy by going for an amended onset date and a quick victory. So that could be also another way to look at it. A lot of different ways to look at this. But again, I would look at it as my first thought would be that shows things have gotten worse, and that says to me we may have a issue with arguing about the original onset date. But again, I would defer to your lawyer about that. Randy, how are you doing? Thanks for responding. Yes, I have an additional question. When I correct and sign the initial application, would it be better for me to email it to you? Yeah, I think that it's never a bad idea to let, and what I told you in email, obviously, Randy's one of my clients, is I'm happy to submit paperwork, documentation. I don't yet have electronic access to your folder, but what I would do is I would fax it in, and then of course I would have a copy, and as soon as I get access, which should be any day now, then I can make sure that it's there. But yeah, I'm happy to submit it for you. At the very least, make me a copy of it. But yeah, if you want to send it to Jen, I just send it to Jen, and we'll go ahead and scan it or fax it to us. We'll go and get it submitted, and that way we have a copy. I like to have copies of that stuff anyway, but that's what I would probably do. Carolyn, yes, hi, Carolyn. We talked before. We talked earlier today. There you go. Okay. Yeah, that's exactly right, Randy. I put it in your file when I get electronic access, which hopefully I will soon. It's kind of weird that they, sometimes I get electronic access literally within just a few days. Sometimes it takes a month. It's just, realize Social Security, one trend I will tell you, Social Security is backlogged. And, even though giving me electronic access is a one-step, checkbox on a computer someplace, somebody has to do it, and you got to have a live person to do it. All right, Jeff says, I'm currently working, but applied in 2018 to back issues, was denied. I was 48, then I'll be 52 and 53 in June. I have a severe osteoporosis due to 40 plus years of taking seizure meds, which caused the bone loss without following in the listings, and yes, I'm still taking the seizure medications. You might have a better argument under the grids than the listings. I haven't looked to see whether there's a listing for osteoporosis, but generally speaking, musculoskeletal listings are very, very hard to meet because back problems are the number one reason people file for disability. So I would tell you that, if you're still working, unless you are literally having fractures, microfractures on a regular basis, I don't know that would be listing level. But I think where the grids come into play is that at you're 53, let's say you're 53 and you're under 55 and you apply, you've got to show that you're limited to sedentary work. Well, if I would assume if you've got osteoporosis, is that what you said, osteoporosis? Yes. Then lifting is dangerous for you. And that lifting, 20 pounds is a problem. If you have a doctor say that, well, that's what you need, or being on your feet for 6 hours a day could be a problem. That's what is required by light work. So you can eliminate light work and you're limited to only sedentary work, you win under the grids, like 201.14. Go to gridrules.net to look it up. But yeah, I think, in fact, I'll put that on the screen here. But the grid rules, where to go for that. But yeah, I think that the grids are probably a better argument than the listings because the listings for musculoskeletal really, really, really difficult to meet. And I just don't, know that I would assume, unless you're just really not able to walk, that you're going to meet a musculoskeletal listing. Very, very hard. And, the few that I get early on are people that are 58 or 59 or 60, with multiple herniated discs and that are using a cane or a walker. That's the level of impairment that you need to meet a listing, in my opinion. JMac, diagnosed with major depressive disorder and PTSD, cannot focus to engage in work-related tasks on a consistent basis. Severe back problems, diagnosed 48. What more do I need? Let's just break it down here. Severe back problems, and I always start with the objective stuff first. In other words, you have a medical issue that is objectively determinable. That's your back problem. Do you have an MRI, or something like that, a CT and MRI that shows a significant back issue, disc-related, nerve-related? Having severe back problems, that could mean, what? I mean, that you have pain, but you have to have some, something to support the diagnosis. And ideally, a doctor saying that you have significant functional limitations arising from that. So you eliminate categories of jobs that require lifting of more than 10 pounds or standing for more than 5 or 6 hours. Now you're 48, so you're not in grid rule territory yet, but you can still eliminate a lot of medium or heavy, maybe even some light jobs because of the back issue. Now we have what they call, and that's the back issue, by the way, is called an exertional limitation because it's based on how much you can exert. The depression and PTSD are non-exertional limitations, meaning they're based on some sort of mental health issue, not on physical capacity. And that could be what would put you over the top, meaning that if you have support to say that, from a psychologist, somebody who's treated you, psychologist, that you don't have the capacity to focus, maintain attention and concentration, that eliminates all skilled and semi-skilled jobs. And then you start knocking away at unskilled jobs because you'd be off task, is the term they use, for more than 15% of the day. You're likely missing more than a day or two of work per month. That is unacceptable absenteeism. So you put those things together, but I think at 48, you're going to need medical support from a treating psychiatrist or psychologist, or ideally both, to talk about the specific limitations, not that you've got PTSD and depression. You don't win on a diagnosis, but you have limitations that arise from these conditions. And because of the back issue, here's an MRI, you have limitations that arise from this diagnosed and objectively determinable medical condition. Put them together and you eliminate all jobs. That's how you have to win. So, you've got some work to do, but it's winnable, but you've got to have the medical records to support it. Ms. Crystal, how long does it take to hear back from a hearing? I had Will, my attorney, let me know. The vocational expert said I could do a mail clerk job, but not in a post office. I was confused. Well, first of all, I want you to realize one thing important, and that is that the questions that the judge asked the vocational witness, there may be 3 or 4 or 5. And many times the first question contains minimal limitations. And the vocational witness will say, well, based on, the person needs to avoid climbing ladders, ropes, and scaffolds and hazardous equipment. Well, that's not going to eliminate, most jobs. So based on that, the claimant could return to past work, or there's any number of other jobs he or she could do. Let's add to that. Now this person is limited to light work, no bending, kneeling, crouching, crawling, or stooping. Well, that's going to eliminate more jobs, but not every single one of them. Then we get into the, off-task thing, or we get into other things that are more debilitating. if the vocational witness said you could do a mail clerk job but not at the post office, if you've worked at the post office, that means that you can't do past work. So now Social Security has to prove you could do other work, but obviously if the last question the judge asks, we got the answer that you could do a mail clerk job, that's not a good sign, because obviously, the judge is sensing that you have the capacity to do work. Hopefully your lawyer asks additional questions that would eliminate all jobs. But generally speaking, if you can get the vocational witness to answer no jobs to one of the judge's questions, that is a positive thing. Obviously, if your lawyer asks the question, it should be no jobs. But again, that's your lawyer's question there. It just really depends on how many questions were asked and which one the judge chooses as being representative and reflective of your potential capacity for work. One of those questions is what's going on in the judge's mind. We just don't know which one. As I mentioned before, it could be 3, 4, 5, 6 weeks before you hear anything. and that's just because of how about backlog they are. Okay, so another job, be a highlight paperwork. So yeah, again, the vocational witness is going to identify jobs that you might be able to do. And, sometimes there are lots of jobs identified because the hypothetical is very non-restrictive. The more restrictive the hypothetical gets, the less jobs it ought to be. But if the judge stops asking questions, that's usually not a great sign. Leave it at that. Okay. Okay, due in part to retro pay, ditched H&R Block, moved to higher level things, knows SSDI, it's time for me to step things up anyway, re-tax. Yeah, and I always tell people, obviously places like H&R Block, they do returns. I will tell you, I had at one point a client from a different area of practice who worked, he was like a manager at H&R Block, and for years I would refer him people for tax returns because he knew what he was doing. He did a really good job. Obviously H&R Block hires a lot of seasonal people, some of whom are going to be more knowledgeable than others. What I a lot of times will tell people to look for is somebody called an enrolled agent, and these are people that have training to do tax work. They're not tax lawyers, but they're also more trained than a tax preparer. And that may be a good middle ground if you have an unusual tax question. Of course, a good tax preparer can figure out and knows how Social Security works, should know how Social Security works. But yeah, you get what you pay for, like anything else. So sounds like you've stepped it up, like you said, and that's not a bad thing to know. Get somebody who knows what they're doing tax-wise. Okay. The postal worker. So Mentix is talking about Crystal's comment that they said, I think she said that they said that you could do a clerk job, but not a postal job. So, that just says that the postal job might be a higher skilled job than a mail clerk. In other words, mail clerk may be like a transferable skill from being a postal clerk, because a postal clerk, for example, may have to know how to, deal with customers, give change, do certain things. There may be multiple tasks that person does, whereas a mail clerk simply gets the mail and sorts it and gives it to whoever they have to give it to. So it's kind of a subset, if you will, of a postal clerk. Okay, let's see what we got here. We have Mike Rodriguez. I've been going on 5 years off work and I had to have surgery on my lower back. What are my chances? I'll be 48, still have back issues and pain. All right, so Mike, if you've been off work for 5 years, generally speaking, your insurance credits for SSDI are going to run out. Typically, they follow you for about 5 years after you stop working. So one thing that you want to try to find out is what they call your date last insured, or DLI, for disability. You can get your My Social Security Statement, ssa.gov/myaccount. That will tell you if you're still insured. It won't tell you at this point your date last insured, but if you look, you can do the calculations in theory. But basically, if you see a bunch of zeros, then your insurance is going to run out probably this year in 2025. So, your onset date needs to be before your insurance credits run out. Maybe you can call Social Security and say, what is my date last insured for SSDI? You're 48, so again, you've got to prove that you cannot do any kind of job at all. You're a surgical candidate, you had surgery, that is suggestive of something pretty significant. How are you doing now? Have you gotten better? Is there a closed period, you could argue? 48, could you say, well, from the time I was 46 to 48, I was disabled. Again, if you have not applied yet, you can only get paid 1 year back. So your onset date may be 3 years ago, but you only get paid 1 year back. So a lot of things going on there. So I think that you still have back issues now. If you're going to apply, go ahead and apply as soon as you can, I would tell you, and then to allege an onset date going back 3, 4, 5 years. You may have to amend it, but you'll find out later what your date last insured is, and as long as your onset is before your insurance credits run out, you'll be good for SSDI. But this is, generally speaking, based on what you're saying, as I would tell you, don't wait. There's no reason to wait because that can just make it more difficult in terms of qualifying. All right, Krusty Critter. I see why they call you Krusty Critter. Let me just say this, and I'm going to respond to this, as a legitimate response to it. There are people out there, and I've had people say to me, "Look, I had a guy I've known all my life, a friend of mine, and he said to me, and he's owned a number of different businesses. Although it's interesting enough, his wife is very, very left politically. I'm not sure about my friend, what his take is, but he's like, I know that most people applying for disability are exaggerating and faking it. I said, really? How do you know that? Well, everybody knows that. Well, let me tell you, I've been doing this for 35 years. Very few people, very, very few people that I've run across are faking it. Somebody might have may have come to a conclusion that their limitations are more significant than the medical evidence says, but very few people are really out to try to scam the government. It doesn't make sense. I mean, you're going to wait 2 years, maybe longer, for a decision. If you do get paid, it's going to be $24,000 a year, $2,000 a month, $2,500 a month. Not that much money. You got to worry about the reviews. And quite honestly, for most people, not everybody, for most people, not working, you lose part of your identity. You're bored. You don't have your socialization. It's not fun. And so, I think that most people, if they could work, they would try to work. They would. So I know Krusty Critters, I'm not going to be able to convince him, but, I think that's just not the reality of what I see. And I've done this for a long time. And if you're going to go for disability, you need to know as much as you can about it, and you need to make your strongest case for it, because for many people, it can be life or death. So, with all due respect, Krusty Critter, I think your premise is wrong. You're assuming that most people who are applying for disability aren't deserving of it, and it's just not the case. So, yep. Okay. J-Mac, psychiatrist, an MD, not a medical, with an MD, not a medical degree. Okay, I'm not sure what he's getting at, but psychiatrists are medical doctors. Psychologists are not. They're talk therapy. Psychiatrists can prescribe medications. Psychologists cannot. That's the big difference there. Okay, can I cancel my application to avoid an offset of a lump sum I got from workers' comp? Will SSA take all the lump sum? Not that they will take it, they just won't pay you. Now, if they see you've received workers' comp and there's no Hartman language, now realize something. If you have workers' comp settlement and it's got Hartman language in there, Hartman language being language that says this $85,000 is not, it should be treated as if it was paid over Lulu's expected lifespan, and therefore is not going to be offset your Social Security. It may offset $50 or $75 of your Social Security every month, but it won't offset all of it. And so it can preserve your lump sum. So before you cancel your disability application, talk to a disability lawyer and look at your workers' comp settlement paperwork and see whether or not, you might have, might be able to protect it by the Hartman language. Now, if you have applied for benefits, you just got your settlement, up until the time you've been getting benefits from workers' compensation, that offsets SSDI dollar for dollar in terms of your past due benefits. But as of the time you settle the case, it starts to become this long-term reduction, very small reduction month by month, and it may allow you to get a lump sum settlement from Social Security. I know that's a little, it's a little confusing, but it's talk to a disability lawyer or comp lawyer about that. Falling Star Catcher. I'm 60 and recently approved for SSI, SSDI. Okay. How can I find out how they decide that I'm disabled? Since I listed multiple impairments. Doctor's office said they never got records. I went to their docs. If you got approved administratively, meaning you didn't go to a judge, you won't know what they used, what they decided to base their decision on. If you went to a judge, the judge will say in the decision. You know, I suspect you could do a freedom of information request to find out what the basis of it was, or maybe even reach out to the adjudicator. Usually they're going to, if the medical evidence is really strong about one thing, it'll be pretty obvious. But, I would tell you, if it's done at the adjudication level, maybe just call and ask, what's it based on? Now, my understanding is there are some codes that are assigned to your case, and that's the base that they'll determine what you are approved for and whether you should be reviewed. But that's not something that I think the public is going to get access to. I still got to find the guy who told me about this and find out more about it, but that's my understanding. But I think the answer to your question would be I would ask the adjudicator. Trish, hello, Trish, how are you doing? Another regular here. Lulu says, my lump sum was 4 years ago, never had SSI or Medicare, was given 85, 20 year of work, my injuries was released, I should cancel. Again, I'm not going to offer you legal advice here. I would talk to a disability lawyer. If your $85,000 lump sum was 4 years ago, and you had Hartman language, then it's not going to offset your SSDI hardly at all. And so I don't know that I would cancel. That's just my gut. Laura Boudreau, would SSI force me to take my pension and Social Security early if I'm disabled? No. You can keep you can go on full retirement age. You can go to full retirement age, which would be 50 or 65, 66, 67. You won't have to take it early. Michael, I was diagnosed with retinitis pigmentosa with severe peripheral vision loss. My center vision is 20/70. Would that be enough? I would look at the listing. Listing. And if you look at listing 2.02, 2.03, and 2.04, I'll put that in the link here. That's will give you your answer as far as what you need. I don't think 20/70 is going to be enough, but the peripheral vision, like for example, they talk about a loss of visual acuity limits your ability to distinguish, detailed, read, or do fine work. I think if you just have a loss of peripheral vision, not just, but if you have a loss of peripheral vision, then you're not going to be able to do jobs, at unprotected heights or in hazardous equipment. But could you do a simple packing job? Probably. So I just think it's going to depend on, how bad the vision is and how it limits you from doing, simple and unskilled kind of work. Okay, so we're talking about the psychologists and psychiatrists before. Okay, Deb says, good evening. I have mild cognitive impairment, chronic migraines, lumbosacral polyradiculopathy, and stenosis, fibro, chronic pain, and arthritis throughout the body. I haven't applied yet, but my last day of work will be 1/31. I'm 56. Support letters from doctors. Being 56 helps. Again, the stenosis, radiculopathy, it just depends on what the MRI says. But, the fibro, I always take fibro and sort of put it to the side because I don't like to base a claim on fibro. It's really hard to win because it's so subjective. I would say this, based on what you're saying to me, the thing that jumps out at me is you've got mild cognitive impairment, migraines. Those are non-exertional impairments. So if you look at grid rule 202.06, you're 56 years old, the cognitive impairment, the migraines, are probably going to limit you from any sort of transferable skills into skilled work. You've got, the back issues that are going to probably limit you to no more than light work. You probably grid out, 202.06. So I would say that may be that would jump out at me. It says to me, you've got a pretty good argument. Again, without looking at the records, I can't say for certain, but big picture, that sounds pretty good to me. Okay. I think this is like ongoing communication there from Esmentix to various people, which I appreciate. Like It Is says, hey, like it is. Okay. Neuropsych and neurologists get, yeah, those are specialists. Those are always good. I think, as Mentix is pointing out, that the more letters after somebody's name, generally the better in terms of their credibility and what judges will think about them. Koo Thunder. Good evening, Koo Thunder. Do I use up my trial work periods for jobs I work for only 3 months? Well, first of all, the earnings, you have to have your earnings in 2025. Let's see what the trial work period is. Trial work period in 2025 is going to be $1,160. So if your gross earnings are less than $1,160 per month, you don't use up a trial work period month. If they're more than that, you have 9 trial work period months in any rolling 5-year period of time. So if you work for 3 months, you're using up 3 of them, and you work for another 3 months next year, you've used up now 6. Another 3 months in 2027, that's all your nine trial work period months. You work in 2028, another 3 months. If you're under SGA, no problem. If you're over SGA, you're in overpay status. I know it's confusing, but once you use up your trial work period months, the next question is are your earnings over substantial gainful activity, which in 2025 is going to be $1,620 a month. In 2026, it'll be something else. We don't know yet, probably $1,700 a month. 2027, it'll be $1,750. Who knows? We don't have those tables yet. But as long as your earnings stay below SGA, you're fine, even if you use up your trial work period months. What the trial work period months basically do is you get paid from Social Security while you're working. So you'd basically double dip, right? Once you use them up, you stop getting that double dip. You don't get your benefits anymore, but you don't get into overpay unless you exceed SGA. Tony Erickson, how long does it get your first appeal? Well, if you apply and you're denied and you appeal, which is called the request for reconsideration, generally speaking, the time frame is you apply, it's going to take 8 to 10 months to get a decision. You appeal, it's going to be another 6, 8, 10 months to get a decision at recon. You file for a hearing, usually 6, 7 months, you get a hearing. That's the general time frame. Your mileage may vary, but that's the general time frame. Okay, so Rodney says he called H&R Block. They said if Social Security is your only source of income, not required to file taxes based on 1099s. Again, I will just say that I think tax issues, everybody's tax situation is different. You should seek guidance, a tax preparer, enrolled agent, somebody who knows about taxes. Don't rely on, I'm not a tax expert. I don't think Rodney's a tax expert. So don't rely on what you hear or read. Make an inquiry about your particular situation. And Rodney, that's not a knock on you. I'm just pointing out that we're not tax experts, so we have to be careful. I don't want to give advice to people incorrectly about tax matters. Blessed Anita. Blessings. We got a blessings from a Blessed Anita. Well, I could use all the blessings I can get. You're in Rampa. I think you mean Tampa, Florida. I don't think there's a Rampa, Florida. 62. I've worked since 23. Denied disability 3 years. I have breast cancer, fibro, lung disease, hernia disc. Judge says I can work. Really? That's pretty crazy. And again, I've looked at the medical records, but on the face of it, you're 62, you've got significant problems. I have a question about this, so if you're within the 60-day period of, I'm not sure what the 3 years start 8, I don't know what that means, but if you're within this 60-day period of getting a denial, have somebody look at it for possible appeal, because that just doesn't smell right to me. I can't believe you got denied. Rock. I read in July 24 article taking 23 months start to finish in North Carolina. Yeah, that's kind of what we're seeing. That's pretty typical. Florida and Texas are the worst, but 23. That's been my experience. Yeah. Dementia Rose, my 16-year-old just had her SSI hearing, I guess. Judge had a good conversation with 16-year-old alone, said she's one of the latest medical records, good or bad signs, severe scoliosis. I've actually won scoliosis cases for younger people, so she might be listing level at that point. Yeah, I think the fact that he wants more medical records is a good sign. And, that's one of the few areas, severe scoliosis, that you can win even if you're young. And I've won young cases for young people in that because it limits you tremendously. And I wish you the best, Denisha. Chris, my lawyer talked to me about it. Okay. So yeah, if your lawyer Crystal was the person who talked about it, amending an onset date. And I said, your lawyer should be talking to you about it. And she says, yes, my lawyer did talk to me about it. That's good. Okay. No, we have another hour. This is embarrassing. I don't know where my onset date came from. Worse, I cannot locate my original application. I'm trying to get a hold of it. I would tell you, first of all, you can contact Social Security and ask them what's the onset date, you know where it came from. If you think it should be pushed back, and you're still at the initial recon, say, I want to push it back because I think the evidence would support that. If you want to move it forward, that's never going to be a problem to something more recent. It just needs to be supported by medical records. That's the key. So the question I would ask is, what's the earliest date medical records support the notion that I am not able to work at any kind of job? They don't look at making zero progress, looking at notes. Yeah, okay. Doctors have big egos? No, I've never seen that at all. Neither do lawyers, which is really kind of cool, right? Okay. Hello from California, Christina. Hello. I hope you're not anywhere. I don't think you are, but I hope you're not anywhere near the fires. I have a first cousin who lives in Culver City, California, and she's southeast of the fires, but it can move real quickly. So, I hope you're not near there because that's pretty scary what's going on out there. But hello, Christina. Good to see you again. Hello, Vince. How are you doing? Another one of my clients. How are you doing? I would never use onset. Really arbitrary. I used a rep, but not a lawyer. And is the onset date, as Mentix, is it too far back? Is it does it need to be pushed back, pushed forward? What is the deal? And I will tell you, it can make it delayed if let's say you're an initial recon and you say, well, instead of being March of 23, it should have been March of 21. Well, now they've got to start getting records going back those additional 2 years. It will cause a delay. So, that's the downside of moving the onset date backwards. Moving it forwards is not going to be a problem. Okay. Oh, so it looks like Mentix has been approved. So if you've been approved, it's kind of hard at this point to start messing with the onset date. I'll just tell you that's my take on that. Robert Long. Am I seeing an increase in the number of disability applicants with early stage dementia? Yeah, I am. I'm seeing more of those. I wouldn't say it's a huge number, but I would say I see several of those a year. And yeah, I'm not sure what's causing that, whether it's environmental toxins or who knows what. But yeah, I never used to see those. And now I do probably see a few a year. So yeah, it's not a huge number increase, but definitely more than I used to. Jeff, you are very welcome. Degenerative disc disease, DDD. Okay. Denisha. Okay, we have same wish. I hope you're not in the fire zone. She's in Pennsylvania, originally from Monterey Bay, in missing California. Is Monterey because we were there one time, beautiful, if it's where I'm thinking is. It was really, really nice. Just a real, beautiful terrain there. I hope they didn't get hit because it was really nice out there. Bob, hello, sir. Thanks for doing this. You're welcome. Approved in February of 24. Back pay was included from 22. Having some difficulty finding a tax account for me with how to deal with this situation. Yeah, again, I would reach out. I would go and look for enrolled agents, ENROLLED, enrolled agents, and I know a National Association of Enrolled Agents, and look for somebody in your zip code and start making some phone calls, or just type in, if you live, I know where you live, let's say you live in Pittsburgh, enrolled agent Pittsburgh, and you'll get some that come up, and they should know what to do. Don Best, got a call from DDS, wanted information on your past work, told my claim should be done today. Anything to glean from this phone call? That's probably good news. Well, I should say this, they're trying to complete the file, but they're telling you it's going to be done today. That's probably good news. I mean, you never can tell, but that's probably good news. It's always good when they tell you it's going to be, you're going to know one way or the other. That's a good thing. Harold, I'm 61 years old and just got a letter from Adjudicator saying got my medical back on December and wanted to talk to them about my work history for the last 5 years. Again, that's part of what they're doing to put the file together, looking at your past relevant work for the last 5 years, looking at the medical evidence, making a decision about transferable skills, things like that. That means your case is being actively worked, which is a good thing. But I wouldn't draw any conclusions, positive or negative, from that. Robert Long, what's the common sentiment about applicants with early dementia, early onset dementia, and Alzheimer's, Parkinson's? I think my experience has been judges realize these conditions don't spontaneously get better. There's not really any treatment for, Alzheimer's and dementia so much. In Parkinson's, they can kind of try to keep it at a level, and where you're plateaued, not getting any worse. So you're not going to have a situation where a judge is going to think it's going to get better. I think you're likely to find more judges saying, I'm going to give this person the benefit of the doubt, and I'm going to accept what they or the evidence says about what they're going through. So I think it, as difficult as the diagnosis may be, it's probably something that's going to benefit for Social Security, your case there. I have a number of Parkinson's cases right now for people, which is another area that I'm seeing more early Parkinson's cases, that, even if your functioning is not at the point where you're non-functional, it's moving toward that direction. And given the long time frame these cases take, I'm taking these cases early on, because Parkinson's, as can be not just physical, the rigidity and so forth, but can also be, can affect you mentally, your memory, processing, cognitive capacity, and so forth. Excuse me. All right, Crystal, we've had sort of an ongoing conversation about what happened at her hearing, and if the vocational witness says you can't do past work, then the burden of proof shifts to Social Security to prove you can't do, that there's no work you could do. Step 4, the sequential process says that you have to prove, that you cannot do past relevant work. So the vocational witness says you can't. Now, Social Security has to prove that there's, there's something you could do. So just for legal purposes, it's called a shifting of the burden of proof, which again makes your life a little bit easier. But at the end of the day, you want the judge to conclude that there's no work you could do. But eliminating past work at least gets you to step 5 of the sequential evaluation process. Yeah, you're right. I mean, as Mentic says, after your condition has derailed your career, it's humiliating to be said you could work as a mail clerk and whatever. And yeah, I mean, the example I always give would be, imagine somebody said to you, here's a job, you're sitting in an air-conditioned warehouse, a climate-controlled warehouse, and putting ink pens in a box. You have a PhD or an MD or an engineering degree, but if you can do one of these entry-level warm-body jobs, and you're under 50, let's say, then you're not disabled. So yeah, it's not that they're saying that there's a job for you, but if you could do one, and people say to me, well, I can't survive on that. Doesn't matter. Minimum wage, doesn't matter. I have no transportation, doesn't matter. Could you perform one of these simple entry-level jobs? At SSI and SSD, I do get back pay. You get the higher of the two. If you got SSI, you get SSI for the 5-month waiting period, then SSDI kicks in and offsets. You don't get double the money. You just get the higher of the two. Mike says, have counsel help me appeal because it's denied. It's gotten worse while being off work, currently waiting a decision. Yes, they're backlog. Pardon me. I don't know why. Actually, well, I don't know why I'm so tired today. It shouldn't be, but I am. Okay. Had too many carbs. That's why I definitely had too many carbs today. I'm going to try to limit that, but had some popcorn and I had some pita chips. So can't do that. Got to stop that. Crusty Critter. Okay, and again, I think this is just an example of that people are not out to scam anybody. They're just trying to survive, really. Christina, as always, asking people to thumbs up the video, which I appreciate that. I'm going to put up here. If you are enjoying this, you want to leave me a review, you can do so there, which I would greatly appreciate. Okay, approve it reconsideration. Okay, great. That is good. I guess my question skipped over. I'm 60. I've been denied 3 times. Judge told me I could work with breast cancer. Well, again, I answered before, Anita. I think that if you're within 60 days, you should appeal it. If you're not, you could reapply. There's got to be something going on here because, I just can't see why you would be denied. I mean, with all these conditions. Now, the fibro is not going to probably do it, but, herniated disc, lung disease. Now, the real question here is now, do you still have insurance credits? If you've been denied twice, 2 hearings, or 3 times, it may be long enough where your insurance credits have run out and now you're in SSI world. I don't know, but obviously there's something in your medical record that is, not convincing judges, or you just happen to get unlucky and draw some really, really tough judges. But I just can't believe somebody who's in their 60s with herniated discs and lung disease and breast cancer is going to be denied. The profile doesn't fit. Faud, who's been here several times, spinal stenosis with the judge denied at the hearing, didn't mention listing 1.16 that showed an MRI. Hope to get a decision appeal. Lawyer says a good case. Okay, well, I'll stick with what your lawyer says. The judge, needs to talk about in parts of in doing the 5-step analysis whether you meet a listing or not. So the judge should say in that decision that he's decided you don't meet a listing. But again, if your lawyer says you've got a good grounds for appeal, then hopefully his observations will be correct. Kind of discuss getting approved as type 2 diabetic. Sure. A couple things about diabetes. Number one is it used to be a listed impairment. It's not anymore. So what that says to me is that they're looking at it's there, but they're basically saying evaluate under the symptoms and the part of the body that's being affected by it. So generally speaking, type 2 diabetes is pretty common. So again, it's one of those common conditions. A lot of people have it. To win on diabetes alone, my experience, it's got to be pretty significant. It's got to be uncontrolled and or has caused organ damage because it was uncontrolled for a long period of time. The type of problems that you would see, as you certainly know, neuropathy, numbness in the hands and the feet, other parts of the body, retinopathy, problems with vision. And again, if it's permanent damage, that's going to make that case that much stronger. If it's uncontrolled and you're having these fluctuations of 350, 400, down to 50 or 60 and you're losing consciousness, that can be a problem. A lot of times people with diabetes type 2 have to urinate frequently, 45 minutes to an hour. So if you have evidence that says that your diabetes is not under control, that despite insulin, and usually they're going to look for people on insulin as opposed to metformin or some of the other pills. But if you're on insulin and your blood sugar is out of control and you're urinating every 45 minutes, that is going to be disabling. So it's just, I would say, big picture, to win on diabetes alone, it's got to be out of control and symptomatic, and or have organ damage that is not repairable. It's not going to get better. That limits your functioning. Remember, this is all about your capacity to function. not the diagnosis. Thank you, Christina. Please, I really appreciate that. You can go to Google, you can go to Avo, you can go to any number of places. What's Yelp? Although I don't really get people from Yelp too much. Facebook. I've got to type in Ginsberg Law Office's Facebook page. You can go there. If you go to this link, you can see all the places. But yeah, I would appreciate the review. Thank you in advance. Okay. Jason had a CDR last January, got reapproved. Great. Letter may have another one. How many years? Yeah, again, it's just going to depend on your case and how they code it. I'm guessing probably, every 2, 3, 4 years you're going to get a review, be my guess. Eunice Sala, thank you very much. You were very welcome, Eunice. Christina, don't forget to like the video. Thank you. Yes. Amen to that. Yes, thank you. I appreciate my fan club is out tonight. That's great. Jan Bridgman, I'm 55 years old, working paid in the SS. Until 8 years ago, worked for a school district, TRS, have an injury, want to know, understand, poverty, disability, back and neck injury. Well, if you paid in and you haven't paid in for 8 years, your onset, your date last insured may be, 2 or 3 years ago. So, you need to find out what your date last insured is. And if you have teacher's retirement in lieu of Social Security, you may not have enough credits. That could be a real problem. And so if you don't have any credits, then you've got to, or your onset date would have to go way back to the time you were insured. It's going to be more of an uphill battle. So you can file, but you need to find out. Get your My Social Security statement. It will be the first thing I'll tell you. And then call Social Security and ask them, what is my date last insured? And, can you prove your onset was before your insurance credits ran out? But again, if you last worked 8 years ago, which is say 2017, that tells me your insurance probably ran out in 22, about 5 years after that. Okay. So Christina lives in Bakersfield, about 80 miles away from the fire. That's, 80 miles sounds like a long, but with those winds, it can be quick. So definitely take care of yourself, Christina. Monterey Bay is beautiful. Yep, we were there. There was one place we went to, it was like the sardine capital of the world or something. I'm not sure if that was Monterey or some other place close by. I remember we went on in fact, I've got this picture someplace. I'm kind of an amateur photographer, and one of my first, I got a real camera, and I took it out there first time. And I got some great pictures of these sea lions, there was right on the bay, and sea lions were kind of fighting each other, and it was really pretty cool. And not fighting, but they were kind of jostling for position. And so I got some really neat shots of that. So yeah, it was really pretty out there, and it was very nice. Just walking along the small town and so forth. It was beautiful terrain. So yeah, I hope that it's not that doesn't get hit. Thanks for sharing. Sure, that's Masanja. Absolutely happy to do so. That's why I do it. Thank you. You're welcome. Wasn't it changed once? I just don't know how the HUD is determined. Never requested it necessarily to set those. No more. That's okay. You're welcome to ask as many questions as you want. Normally, you set it up. I mean, now I've had people tell me that they call Social Security, and somehow or another there's an onset that gets in their file. But theoretically, they should ask you what date you last worked or that you last lost the ability to work. They shouldn't be making those decisions. Denise, you have a lot of friends because Monterey I'm sure it's expensive. It's so pretty up there. And I guess Bakerfield's not on the water, so that would be. Are you taking new clients for the time you're passing on another professional? It depends. I mean, I have a certain capacity. I mean, I've always wanted my firm to be small enough where I can interact with my clients. And so, I typically take about 10 or 15 new cases a month. And if I start to get close to that fill up, I will refer out to some other people. There are people that email me and say, I want a live hearing, or I want somebody on the West Coast. So I'll refer them out there. So I do take some cases, not every single case. It's just, I look for ones I think that are interesting. But if I'm getting too busy and I've got too much stuff going on. I don't want to overwhelm my staff. I don't want a mega firm. I don't want to take in 100 cases a month. I'm fine with 15, 18, maybe 20. And my staff is, we can handle that. But once we get too many, it starts to break down, and I don't want that to happen. So I am taking cases, but, I'm taking them as I can take them. And again, every month I do have a certain amount that I take. And honestly, I try to take good cases. I mean, we only get paid if we win. So I'm not going to take a case for somebody who I don't think has got a winning argument. Although I've got a hearing coming up next week, got a 35-year-old with seizures. That was a case I felt like I could win, even though he's very young. But yeah, I mean, I get people that reach out to me that are in their 30s with a bulging disc. I'm probably not going to take that because, again, I can't justify spending 2 years of my time and my staff's time on a case that's a very low likelihood of getting approved. Approved at recon, that is very rare, very, very rare, absolutely. I've had a few approved at recon, but it's tough. Mr. Flipster, I have myasthenia gravis. I'm 49. Is this a good case? It depends on the symptoms. It depends on how it affects you. You don't win on a diagnosis. You win on the effect that your condition has on your functioning. So the question I have for you is, what are the limitations that arise from this? How do they affect you? Would they prevent you from working a simple entry-level job? Asked about SSD and SSD back pay. Received 3 checks to say SSD memo line. I'm asking about SSD retro pay. Yeah, I mean, I think that, what I see sometimes is people apply for both. It's called a concurrent claim. And the 5-month waiting period, which applies in an SSDI case, there's no 5-month waiting period for SSI. So sometimes people will get a check from SSI that represents the 5-month waiting period. Then they'll get another lump sum check from SSDI. Not sure we got 3 checks if you've got it. And in rare, I will say, the rare cases where the person's SSDI amount is less than the SSI amount set by statute. So let's say that you have your earnings, you worked at very low paid jobs, your SSDI amount is $530 a month. Your SSI amount is $1,000 a month. So you'll get 2 checks, one from SSI, one from SSDI. The total will be the higher of the 2, but you'll get some from SSI and some from SSDI. But it's rare, but it does happen every once in a while. I think it's more about, Kevin says, more about education that the adjudicators lack when interpreting medical records. Well, they actually have doctors that they send the records to review, and the doctors will give them guidance as to what the records say. So if I had to put fault there, I would say it's probably more in the fault of the medical experts that Social Security uses, and maybe the adjudicator not making a strong enough connection between what the medical records say and functional limitations. Realize adjudicators or claim specialists have a very limited authority. They're looking for very specific information. They're not going to assume anything. They just don't have the authority to do so. So if they see an MRI that says herniated disc, but there's no indication from a doctor about what that means in terms of, radiating pain or limitations on strength, they're not going to make any conclusions. Whereas a judge would say, well, clearly a person with a severely herniated disc, stenosis, and nerve root impingement with complaints of numbness in the leg, I'm going to accept that as being factual. The adjudicator is going to say, did the doctor say there's numbness? That's really the big difference, if I had to put it in a nutshell. So the adjudicators just have less authority than a doctor would have. Ross says, have ever won a case for loss of speech? Per the listing, I can barely be heard, but since it hurts, can't sustain even whispering for long, had surgery. I have never had a case for loss of speech. Now, again, the listing 2, it's 2.09 says, I'll read you 2.09. A loss of speech due to any cause with inability to produce by any means speech that can be heard, understand, or sustained. So it says to me, you meet listing 2.09. So, I'm thinking that Social Security is of the opinion that in any job, there has to be a way to communicate verbally. But yeah, this looks like you meet 2.09. I've never had a case like that, but it looks to me, if you look at 2.09, and I'll put the link in here for you. If you apply, I would just say, please evaluate under 2.09. And if you get your doctor to say, yeah, he cannot be understood, can't sustain it, then you win. Okay, Jen says, thank you. You are welcome. MJ, just had my hearing. How long does it take a decision? Glad to catch you. I'd say, anywhere from 4 to 6 or 8 weeks right now. On full retirement, it's been incredible. Oh, good, Robert. I'm glad you find it useful. I have a good time with this, and I think as y'all know, I'm going to have a judge on, a retired judge on in February. I've got a lawyer friend of mine who does, or acquaintance, I don't really know her other than through LinkedIn, who does appeals work. She's going to come on and talk about the appellate process. I've got some other lawyers that are colleagues of mine that want to come on. So we're going to try to keep it a little more interesting than me just blabbing. But again, I know there are a lot of questions, and I'm happy to answer them. You said 35 and disc is an approval. No, I think, I'm not sure what you're asking, but I have a client who's like in his 35, and he has epilepsy with seizures. And I think it's a good case. I'm not sure if that's what you're getting at. Or I was going to say, if I have a 35-year-old with a bulging disc and that's it, that's probably not going to be a really good case, just because they're just not going to approve it. So I'm not sure what you're asking about, but that's what I was just saying. Okay, mid-40s, herniated disc, arthritis of the back, cyst in the spine. Again, you're sort of at that point where mid-40s, so you're not at grid rule territory yet. You got a herniated disc, which is significant. How badly is it herniated? Don't know. Arthritis in back and a cyst in spine. What does that mean in terms of your functioning? Do you have to take unscheduled breaks to lie down, twice a day for 20 minutes or 3 times a week for 45 minutes? What are the functional limitations? You can win at 45 or 46 with those limitations if they're severe enough, but they have to eliminate every job. In other words, your reliability has to be so limited that you wouldn't be able to get through nobody would keep you, because you're just going to miss too much time from work. And that's hard to do. That's hard to do, but you got to have good evidence. Workers' comp. Where do you live, Jan? I mean, my wife, Jody, does workers' comp in Georgia. We don't take workers' comp out of Georgia. So, if you've got a workers' comp case in Georgia, then definitely reach out. But if you're not in Georgia, then I can't really help you. I can try to find somebody for you if you email me, but SSD answers 123@gmail. But not if you're not in Georgia, we can't take it. Okay, Christina, Monterey Bay is famous for Cannery Row. That's the aquarium, right? So the aquarium. There was one place we went, and it was of course, the Monterey Bay Aquarium is very well known, and in fact, you sometimes see food that has got a seal of approval as being sustainable per the Monterey Bay Aquarium. And then Cannery Row, I think at one point, if I'm not mistaken, it was like the sardine capital of the world, but they overfished it, and so now there's not as many sardines there. But it was a very interesting place. If you remind me, I'll find that picture. And I'll show you the picture of the sea lions. It was pretty cool. I got some cool pictures of those. I'll dig them up and maybe we can look at them next week. Libby James says 3 hand surgeries, 2 carpal tunnel and trigger finger, 64, 41 years old. Oh, 64 years old, 41-year-old federal, currently working 5 hours. I guess the federal government working 5 hours and 5 hours OWCP. Still having issues, think of retiring, wait till I finish. Yeah, I don't know how federal workers' comp, I'm guessing it's the same offset. You're getting pretty close to full retirement. You're working, again, if your earnings are over SGA, then you're not going to be able to do very much. My gut tells me that it may not be worth trying to, it may just be stick with what you're doing and till full retirement. It might be an easier way to go than to try to squeeze something out of Social Security. It's just going to take a long time. And you don't really have much more time to go before you hit full retirement. Walmart blamed all injuries on me and said it was my fault. That's like a workers' comp. That's unfortunately somewhat typical of what Walmart does. So if you don't have a lawyer, you need to get a comp lawyer to assist with that. Tammy says, I was told that SSA back pay is paid in 3 payments, SSDI back in lump sum. That is correct. SSI payments are paid in 3 payments. SSDI is 1 lump sum. Yep, that is no bother, but that's exactly right. Let's see here if we got any more comments here. Yes, we do. Monterey Bay is famous for, okay, we talked about that. All right, fibro, incontinence, stenosis, bipolar, injections, pain blocks, didn't help, rotator cuffs messed up. You're 53, Sherry says. Again, the fibro, I'm just going to tell you, is just probably not going to move the meter all that much. The incontinence I win a lot of cases on that. Stenosis can cause significant back issues. Bipolar, again, is going to limit you mentally. Injections, pain blocks didn't work. Do you have any objective evidence of back problems? MRIs, things like that. The incontinence is one thing I think it could be very, very strong. So that may be something to really look at. And the injections and pain blocks, I'm guessing they would have done an MRI to find out what's going on. Again, it just depends on the severity of them. But those conditions could support a decision, yes. You're welcome, Crystal. I'm glad that you have found this useful. Hello from Central Illinois, which I'm guessing is pretty darn cold right now. 56, neck and back, fusion, denied without author records, submitted electronically with recon to protect and take them to the office, also with best grid rule to cite. Look at 202.06 if you're 56 years old. If you're saying that you submitted them, normally when you get a denial of those, it'll say what records they looked at. So if you don't see them on there, they didn't get in. If you submit it with a recon appeal, I would find out whether they've got them or not. You could, again, that's one of the things when I'm in a case, I can look and electronically I can see. You can't, but I would contact the adjudicator and say, do you have these records? And just ask them. And you could certainly take them in. I'm not a huge fan of duplicating records because now that's just going to mean somebody's going to dedupe them. So I would at least try to find out whether they've got them. And if they don't have them, bring them in. If they do have them, then you don't need to send them in again. Sherry, you are very welcome, Sherry. Let's see what else we got going on here. Okay, so looks like is that my last call? Oh, we got some more here. Medicaid is arranged that personnel with SSDI and got approved first time. Medicaid? That doesn't make any sense. I mean, they're not going to provide, maybe I don't know who that was, but I don't think Medicaid is going to give you help with SSDI. That just doesn't sound right to me. But however, whoever did it, you got approved, so that's cool. Robert says it's 11 degrees here in Clearfield, Pennsylvania. We're glad to take 40s. I hear you. I would agree. 11 degrees is bitter cold. That's danger cold. We've actually had in Atlanta in the past, nothing recent, 0 degrees, -2. Again, very rare. But that is like you literally, you walk outside for a second and it's like frostbite. It's really dangerous. No interest in that at all. I'm not, my blood's too thin. Sherry has a prescribed walker and a placard. The walker, more so the placard, yeah, because the walker says that you've got real problems with what they call ambulating or walking, and that's going to eliminate, pretty much any job other than sedentary work. And if you're I think you are over 55 and you're limited to sedentary, you win. So having a walker is going to be a really, really strong factor in your favor. No question about it. All right. Chiquita is in Atlanta, Georgia, which is where I'm at. My hearing in March. Okay. Hopefully you get approved. I hope you do. I had a Chiquita as a client and we got approved. So hopefully you'll have the same result. Hope you got a good judge. I would definitely check out the judges because some of them are a little more reasonable than others. Cajun Sunshine. Okay. We filed in August. We think we'll hear something. Maybe. I mean, it's going to usually 8, 9, 10 months. So August would tell me we're probably looking after, we're now in January. I would guess February, March. Yeah, certainly we'll hear before the end of the year. I'm guessing, March or April would be for our decision. That's my guess. I mean, again, they're just behind. Everybody's behind. But thanks for tuning in, Cajun Sunshine. I think I know who you are, but thank you for tuning in. Right, we have more snow coming. That's what they say. We'll see. We'll see. It's supposed to be really cold. I mean, snow, for us here, it's kind of fun because we don't ever get it. But it's after the first day, it wasn't so much fun. It was just kind of a pain to try to dry because we get a lot of ice here. If I have Medicaid as my secondary insurance while on disability, will lose Medicaid for getting inheritance? You might, because I think Medicaid is means test based. I think. I don't really, I don't know for certain, but I think you might. You might, Lindsay. Sherry says, awesome, thank you. Have a good night to you as well. Do I live near fancy schmancy Peachtree Mall with a Neiman Marcus? I don't know, but now, are you talking about Lenox Mall or are you talking about Phipps Plaza? There's no Peachtree Mall. Neiman's, there's a Lenox Square. You maybe Perimeter Mall. Maybe you're thinking of. If it's Perimeter Mall, I live not too far from there. If it's Lenox or Phipps, a little further away, that's in Buckhead. I haven't been to the mall I Perimeter Mall will go to periodically. I get most of my stuff off of Amazon. I hate to say, I don't go to the mall. It's just I just find the prices are really high, and it's a lot of crowds. And honestly, I hate to say it this way, but the safety, with all the craziness going on out there, I don't want to be in a mall with a lot of people. There have been some shootings at some of these malls. We're getting near that stuff. So. I forgot I'm hearing by telephone as an appeal. The same judge who denied you, I'm nervous will be denied. Yeah, some judges get the hint and they'll approve you, others don't. But if it was remanded, there was a reason for it, and many times the remand will kind of suggest to the judge, go ahead and approve this person. Hopefully that will be the case. Yes, okay. I knew the Cajun part. That's why I thought Louisiana. That's why I thought you were. So okay. Well, Pat, thank you for coming by. Sherry, hearings in February. Well, good luck. Jose, thanks for the good help. You're welcome, Jose. Medicaid, okay. No problem. Let's see. How long this consideration appeal? I think reconsideration. It will take 6 to 12 months, depending. If you're in Texas, 15 or 16 months, but most places it's going to be 6 to 12 months. Let's see what else we got going on here. That's actually the last comment. Wow. Okay. Well, we're getting close to the end anyway, but interesting. I actually ran out of comments. We don't normally do that, but actually a little lower, 120 people right now. It's a little light tonight, but that's okay. All right. So you know what? I think we've covered a lot of the stuff. If anybody has last minute questions, go ahead and ask them. The fancy mall. Okay. We got a couple more things. Business trip for Amazon, Jurassic. Yes. Phipps Plaza. Okay. Phipps Plaza is a kind of a high-end mall. They've got all kind of expensive stores there, which I'm not a clothes horse, so that's wasted on me. But Yeah, there's some nice places. I just haven't been there in years and years and years. Is a good evidence. Honestly, I like the phone hearings. I think that I can tell you exactly why. My hearing today, I have a client who's got a fungal infection in her lungs. Okay, and during the hearing, she was coughing pretty continuously. And I just said to myself, if we're live, and you got a judge in a small room, not a whole lot bigger than this, my office down here, and you got a client who's coughing because of fungal infection, you're going to have a really unhappy judge. And unhappy judges don't typically award. So I think judges like the fact that they're a private location. They're not interacting with a bunch of people that have, could have medical issues. I just think they work really well. I think that the phone hearings work great. So, my opinion is that I think they're preferable to live, and at least my take. Others disagree, but I kind of like phone hearings or video hearings. Thank you, Christina. And Madeline, hey, Madeline. Madeline works with me. Madeline, you keep coming with different last names. I'm just using a different computer or whatever, but you have a good night as well. I got to ask you about that because, all right, let's see what we got here. If I get denied by a judge in a cessation case after 24 years, and my next options, you could reply again, but I'm not sure that you would be insured. You could appeal that. You can go to the appeals council on that. That would be the next step in terms of appeal. But yeah, that's what you would do. It's just like cessation cases are just like regular cases. It's just after you've been denied, and you've been awarded, but now they're denying you. So you just go through the same kind of appeal process where you would go to a hearing, and then after that the appeals council, and after that district court. Every year, I probably file 10 plus appeals council appeals. Usually I co-counsel with somebody that's all they do. And I'd say 80% of them, if it may go to the district court, but they get remanded and we get to another hearing. And of those, probably 80% get approved. That's just my numbers. But, my experience is many judges, if you get a remand from the appeals council or especially from federal court, they're going to take the hint that the district court isn't going to take a case unless it's a viable case. So the message is approve this case, because otherwise, they don't want to keep getting appealed and keep losing. That doesn't look good on their report when they are coming up for salary review, I'm guessing. Okay, thank you. It's late for those of us over 50. Well, in that category myself, it is 10:22 p.m. Eastern time. So yes, it is getting late. B name. Ended up getting fully favorable with your hearing. Appeals council has been reviewing for the last 4 weeks. It's a random part of the checks and balances. Yes, it is random. It is really frustrating. I had a couple like that last year. And they are going to look at it, and every once in a while they decide that you're not disabled. Most of the time they just affirm it. But that is just kind of a random type of thing. Tommy says, I meet listing 2.02. Okay, so then you're a visual case that if you corrected vision and the better eye is 2200 or worse, then yes, you meet the listing. What information I need to, I need to know, the questions I always ask would be your age, past work you did, why you feel you're not able to work. Is there objective evidence of that? And really I'm just asking people why they feel they're not able to work. And what the diagnoses are, and is there objective evidence? So, I'll have people reach out and say, I'm 61, I've got severe back pain. And I'll say, Madeline, who's just here, does a lot of work in terms of call screening. And so she'll call up, and she's actually paralegal-ish, so she can, kind of help with evaluation, but she'll call up and say, okay, let's get me the MRI. Let's take a look at that. And, we'll look at that. Get me the evidence, medical evidence, and let's take a look at it. And so it's more than just a diagnosis. We need to see what the functional issues would be. So that's what I'm really looking for. So, I'm looking, obviously people over 50, I'm going to give it a little bit longer look. Someone who's got significant objective evidence, I'm going to give that a longer look, but I look at all of them. If it's something I can't do, or I think that, somebody else would be better for it, I'll refer it out. Or if it's something I just think there's no chance at all of winning, I'll send you a letter back saying, you can continue, get a second opinion, but I don't think there's enough here based on what you wrote. Disabled for 21 or 45, some parent benefits. You think it's possibly a reason? Could be. Disabled adult child, you're 45, so you were probably approved on a disabled adult child. It just depends on, what you worked. It depends on what the medical evidence says. But, you're 45, so that means you're, 20 more years on Social Security. They're looking for reasons to cut you off. T-Lux, you're welcome, T-Lux. We've got about 5 more minutes here. And Tammy Parrott, not Tommy, Tammy Parrott. I'll get the most 12 months back pay from application date. Then do I get the months from application to approval? Yeah, you'll basically get, if you apply and your onset date was at least a year ago, you'll get some benefits going back up to a year and then till the time you're approved. So I've had cases where, I had a case last week where I'm going to have a guy who's going to get, it's going to be a closed period, but like 3.5 years of past due benefits because it's taken a couple of years to get to a hearing. Had to go help my daughter. Thanks for answering the question. We did her case solo because Lou didn't show up with it. Wow. That's pretty crazy. I've never heard of that. But he waived the payment, which is the right thing to do. But wow, that's crazy. All right, big one. Have a great night. Good learning experience as always. Well, thank you for tuning in, big one. Appreciate it. Thanks. Makes a lot of sense now. Well, Social Security in some cases does not make a lot of sense. So I'm glad we were able to put some light into some of this stuff because it can be very, very confusing. Look, Social Security, I think my sense is that, if anything, it's going to become, more difficult to win. I mean, there's a lot of narrative in Congress that people need to cut back on this program. The commissioner we had, O'Malley, was really good. The new guy hadn't been confirmed yet, is coming from more of a corporate background. So, I suspect it's going to become, it's not going to be a positive thing for people trying to get on benefits. After approval, how long to get a CDR? It just depends. It could be a year, it could be 3 years, 5 years, 7 years, 10 years. Just depends. Good night, everybody. It's been a great time. Okay. Christina, please, thank you. It does help a lot. Yes, the more likes and thumbs up I get, the better. That would be great. I would really, really appreciate that. If you have questions, email me directly or just, go onto the website, SSD Answers, and just leave me your question. I can get to it. Doing an attorney completed CDR as a doctor completed. I usually tell people for the form, like the short form or the long form, you don't need an attorney for that. You could do that yourself. If you get denied, you might want to talk to an attorney, or if they move to terminate, but just to fill out the form, no. Have I heard them losing a file? Yes, many times, unfortunately. Many times. They will lose files, and it's really frustrating because people will be stuck in limbo. And the worst ones are the person is stuck in limbo for 5 or 7 years and doesn't realize it. And they finally call up and say, hey, what's been going on? It's been sitting around for 5 years. And we call up and, oh, that file was closed out, or that file, we don't have any record of that file. If it's been more than a few months and you haven't heard anything, got to get on the phone, or at least send a fax in. Okay. All right, Carolyn, great. I'm glad you stopped by. And again, as we talked about our email, if you have anything you need from me, you know how to reach me. Okay, so I think we're kind of at our 2 hours right now, which has been great. I appreciate everybody. And again, we will try to get some guests on. Well, we will have some guests on coming up, but keep the good questions coming. I hope this was helpful, and we will see you again next week. Again, stay warm because it's going to be cold. I think the whole country is okay, Wolf, you're welcome. I hope the whole country is going to be cold. I think it's going to be a little warmer here tomorrow, but it's going to get cold next week. Oh, I'm glad, Denicia, that you got here. Okay, cool. Thank you very much. Okay. All right. Well, I'm going to go ahead and end it now. Thanks everybody for stopping by, and we will. I hope to see you all next week. And if you have any questions, we will try to get them answered for you. All right. Take care, everybody.